Okay, so now we're starting again. This is the second half, and we're going to do two more things about substantive law, and then we're going to talk about how to actually do this in real life and what it looks like in real life. Some of you may remember at the beginning of the program, and I was praising the name of Erica Birch, who came up with this great street law clinic program. Well, one of her colleagues at her firm is here to talk about employment law, and she deserves the same praise. Lucy Juarez. Come on up and claim your prize.
Thanks, Richie. So, are most of you students? How many of you are students? So I just want to put in a quick plug for the Street Law Clinic, because I went to the University of Utah, and I volunteered with the Street Law Clinic there for all 3 years that I was in law school. And it directly led to my job. I was working with the attorneys that I work with now at the Street Law Clinic. I worked with them on a few pro bono cases and stuff, and they liked my work and interacting with me so much that they offered me a law clerk job. They never looked at my resume. They just based it completely on our interactions at the clinic. And then when I graduated, they offered me the job up here. So I definitely think that in addition to just doing some real good and getting some real practical advice, it can also lead to jobs, connections. It's good networking opportunities. So I'm going to go through just the real basics of employment law. Employment law is an area where there is a lot going on, a lot of different statutes, case law and stuff, so I'm just going to try to go through the basics. You're not going to be expected to, I don't know how many of you have volunteered at street law before, I'm assuming most of you are going to be new volunteers, but you're not going to be expected to know everything. But it is good to have some basics so that you know the types of questions and stuff to ask. And I did include an intake questionnaire form that's in your packet that I'll go through at the end of my presentation to sort of explain why we ask those questions. So in Idaho, employment for the most part is at will. What you're going to hear a lot probably is people are going to come in and say, I know this is a right to work state, but, and then go into some story. For some reason, the at will term and the right to work term have really gotten intersposed in general society, and people think that right to work means at will, when in fact right to work has to do with unions. So it's not really, most people won't come in with a right to work issue. Most people will come in with some sort of at will related issue. And what that means, the right to work issue has to do with unions. But at will has to do with the fact that essentially you can get fired for any reason or no reason at all, as long as it's not an illegal reason, okay? And people sort of, most people don't understand what those illegal reasons are, and so that's what we're going to go through today, okay? There's a bunch of federal and state laws that cover employment law, and actually Erica created this super handy handout that I'm going to pass around. Just hand that around. It's got a list of most of the laws, federal and state, that apply in employment cases. It's obviously not all-inclusive, but it's got a lot of them. It explains sort of what the basic protections are, damages, and things like that. So the big laws in employment law are Title VII of the Civil Rights Act of 1964. That covers race, color, national origin, religion, sex. And then there's Americans with Disabilities Act, which covers with disabilities, the Age Discrimination in Employment Act, which covers age discrimination for people who are 40 and over. What that means is that if you're getting discriminated against because you're 25, you're not protected. There's also USERRA, which covers military status discrimination, and the FLSA, the Fair Labor Standards Act, which covers wages, minimum wages, overtime, things like that. So some general misconceptions that you might hear from clients that come into just some basic stuff. A lot of people think breaks and lunches are required at work, so they might come in and complain, hey, my boss doesn't let me take my breaks or my lunches. And in reality, there's no law that covers that. There's no legal requirement for an employer to give you breaks or lunches. It's just basically one of those things that employers do to retain good employees, treat them well. Because if you were working someplace and you never got a break or lunch, you'd probably quit and move someplace else. It's also not a legal requirement for private employers to give personnel files, to give copies of your personnel files. So a lot of employers do it just voluntarily, but they're not required to. There's no legal requirements for that. A lot of people think that playing favorites, your supervisor, your boss playing favorites, treating someone else better than you is illegal. And unless you can tie it into one of these protected statuses that we're going to talk about briefly, it's not illegal. If your boss dislikes somebody else because they're funnier or they have better style than you or whatever it is, if it's something like that and it's not protected, that's perfectly legal in Idaho. And then if failure to follow their own policies, you get people who will tell you that, yeah, these policies, the private employers have policies and they keep, they're not following them, they're not going through the written grievance process or whatever, and in reality, all those policies, I guarantee you, have some sort of disclaimer in them, and there's no legal requirement for them to follow their own policies. Firing you for a stupid reason. You come in one day, your boss doesn't like the Broncos shirt you're wearing because he hates the Broncos, and he fires you. Completely stupid reason, completely unfair, but totally legal in Idaho, okay?
Totally legit.
Huh? Totally legit. And then giving no reason for termination. People often think that they're supposed to be given a reason for being fired, that it's supposed to be in writing. You're supposed to have a fancy little meeting with your boss, and they hand you something in writing and tell you why they're firing you. They don't have to do that. There's no legal requirement for that if you're an at-will employee. So there's federal laws and state laws. I'm going to go over the big ones. The rest of them, or most of them, are covered in that handout that I handed out. Title VII, that's the one that covers race, color, national origin, sex, religion, and also retaliation, which these days there seems to be a lot of retaliation claims. Under Title VII, an employer has to have 15 or more employees. So if they have less than that, you can pursue claims under the Idaho Human Rights Act, but in order for it to be to qualify to be protected by Title VII, they have to have 15 or more employees. And then that applies to all kinds of discrimination, not just hiring and firing. It can apply to promotion, pay, other terms and conditions like shifts that you get stuck working, hours, things like that. Under sex, that covers sexual harassment, which includes quid pro quo, which is your stereotypical boss chasing the secretary around the desk sort of sexual harassment, where someone with some sort of authority sort of lords that over their employee to get them to do sexual acts and things like that. And then there's the hostile work environment, which a lot of people don't understand hostile work environment either. You can be subjected to all kinds of hostile treatment at work, and it can be perfectly legal. There's lots of legal bullying that takes place in the workplace. If the reason for the bullying isn't one of these protected statuses, if it's because you're a Broncos fan, perfectly legal. Even if it's a daily bullying about whatever that issue is, unfortunately it's perfectly legal. So there are legal hostile work environments. But the illegal ones are the ones that apply to if you're being treated, bullied or whatever because of your sex or things like that, your gender. Sexual orientation and gender identity are sort of a new area of the law. Do you have a question?
This is about the answer, right?
Oh, yes. So sexual orientation and gender identity are a new area of the law. We're all hearing about all the changes that are taking place in the law. And right now there's no same-sex, no protections for being homosexual. So being lesbian, gay, transgender, bi, queer, any of those, there's no real protections except for there are new protections for transgender folks. The EEOC has decided that transgender identity is protected under Title VII. It's real complicated, but it's new and upcoming. And sex stereotypes are protected. There's some case law out there. So if someone's being discriminated against because they're not feminine enough and they're a lesbian, then they may be protected because they're not meeting those female gender stereotypes, but they're not protected because of their lesbian status, if that makes sense. It's a very nuanced thing. So with all of these, well, with most of these, Title VII, ADA, ADEA, you have to exhaust your administrative remedies before you can file a lawsuit. What that means is that you have to file a charge with either the EEOC, which is the federal agency, the Equal Employment Opportunity Commission, or the IHRC, which is the Idaho Human Rights Commission, and you usually just let them investigate it. There's also, once you file the charge, you can pull the charge at a certain amount of time, and then you get what's called the right to sue, and then you have 90 days to file a lawsuit. So if someone comes in and wants to file a lawsuit next week against their boss for sex harassment, will be explained to them that you have to go through this administrative process first before you can do that. The ADEA, Age Discrimination and Employment Act, like I said earlier, that only covers people who are 40 years and older, okay? If you're being discriminated against because of your age and you're younger than that, there's no protections. And for the ADEA, employers have to have 20 employees or more. The Americans with Disabilities Act, the employer has to have 15 employees or more. That covers having a disability. It covers being perceived as having a disability. There can also be some association claims if you're being discriminated against because you're associated with someone who has a disability. The ADA claims there's a lot going on there, whether or not employers are providing reasonable accommodations, because employers are required under the law, if you have a disability, to provide what's called a reasonable accommodation if you can do your job, the essential duties of your job, with a reasonable accommodation, then they're required to provide that. The FMLA, the Family Medical Leave Act, that provides up to 12 weeks of protected leave for people to take off for their own condition, to care for a child or spouse. With the FMLA, the employer has to have 50 or more employees within a 75-mile radius, and the employee must have worked at least 12 months and 1,250 hours. So if a person just started at their job 6 weeks ago and they're upset that their employer is not granting them FMLA, they haven't been working there long enough. Okay, they're not qualified. And what that means is their job's protected. At the end of that 12 weeks, they're supposed to be able to go back to their position, okay? And FMLA can be taken in one big chunk in 12 weeks, or it can also be taken intermittently, which a lot of people have conditions where a couple times a month they have to go to the doctor or they have to get therapy, things like that. Your leave can be protected in that sort of situation as well. Wage and hour cases, those usually fall under the Fair Labor Standards Act. That's the federal law. There's also the Idaho Wage Act. The FLSA covers minimum wage requirements and overtime requirements. The FLSA is very dense with exemptions, all kinds of exemptions for executive and things like that, people who are on salary. Lots of times you have to sort of factually analyze somebody's job and what they're doing to see if they're actually exempt from the FLSA, because lots of times employers exempt them even though technically they shouldn't be exempted. The Idaho Wage Act covers wages that haven't been paid. They have a wage claim division where, likely a lot of people come in with small wage claims. We would refer them over there. I think they can collect up to $5,000, and so then they don't have to go through some sort of expensive lawsuit or something like that to try to get their $1,000 that their employer hasn't paid them. And of course, with all of these laws, there are statute of limitations, which I think are listed in that handy chart Erica made. There's wrongful termination and breach of public policy. So this is like sort of the general exception to the at-will doctrine. So if you're terminated and the motivation for the termination contravenes public policy, that can be covered under this claim. It can cover employees who refuse to commit criminal acts or who perform important obligations for the public. So usually most people are employed at will, but there are people who actually have employment contracts. If they do have an employment contract, when you sit down with them, you're going to want to take a look at that. And that's going to be one of the first questions you ask on the intake form too, because the employment contracts oftentimes will outline whether or not the person is an at-will employee or not, whether or not they the employer has to have good cause to terminate them, whether or not the employer has to give them notice that they're in breach of the contract and give them a chance to cure the breach, whether or not there's some sort of severance payment due if they do get laid off, whether or not mediation and arbitration is required for their claims. Oftentimes these days you'll see arbitration requirements in those contracts, whether or not attorney's fees are paid for, and then form and choice of law provisions. All types of things can be in the employment agreement. So if someone's got an employment contract, it's real important to get a copy of that so we can take a look at it. Non-compete agreements, they're pretty popular with people who have contracts. So if you're looking at a contract, look to see if there's a non-compete agreement. In Idaho, non-compete agreements are mostly disfavored. They have to be pretty narrow to be valid, they only apply to key employees. Generally, they should only be about 18 months long. That's the presumed reasonable. Anything over that is unreasonable, and if an employer has a 2-year non-compete, there should have been some sort of consideration given in addition to continued employment. What that means is usually with non-competes, the consideration is just continued employment. Here, sign this non-compete, and you get to keep your job. That's the consideration. But if it's over 18 months, there usually has to be some additional consideration, some sort of money given or something like that. Courts will rewrite non-competes if they don't have to rewrite the whole agreement. If the whole agreement's unreasonable, they have to be tailored narrowly as far as geographic scope, as far as you have to limit the non-compete to what the employee actually did for the employer. You can't just limit the employee from doing all kinds of work. You also have to limit the employee to the contact with the clients they actually had or the geographic areas they actually worked in. So if the whole non-compete looks unreasonable, then the court will probably kick it out. Okay. So let's look at the intake form real quick that you guys have in your packets. Some basic questions to ask when you sit down with somebody who has an employment issue. What was the adverse action taken by the employer? Most people, something happened at work, right? Whether it was they got demoted, they got fired, they got transferred, things like that. So you want to, basically sit down, ask them their story. And as you're listening to their story, you want to be listening for all these things. And if you're not getting this information, ask about it, okay? Because you're going to want to know what exactly happened. Whether or not they have a contract, written or oral, because that will let us know whether or not they're an at-will employee, and other terms as well, non-compete, things like that. Was the employer public or private? There are more protections for public employees than there are private employees. There's more claims. There's constitutional claims, there's due process claims, so it does matter whether or not they're public or private employers. Whether or not they belong to a union, same thing as public employees. If they belong to a union, they may have more protections, which would be outlined in their union's collective bargaining agreement. How many employers the employer has, and as I talked about that throughout my presentation, a lot of the laws have minimum requirements for how many employees. The date of the adverse action, what date they were fired or demoted or whatever, that matters because of the statute of limitations and also the administrative exhaustion requirements. The IHRC, you have 365 days from the adverse action to file a charge. The EEOC, you have 300 days. The reason the employer gave you for the adverse action, usually in situations where there is discrimination going on, the employer's not going to say, I'm firing you because you're black. And so it's good to analyze, if the employer is saying they're firing you because you're a bad employee, figure out why the employer, what evidence does the employer have that the employee was bad, and how do you suss out that the real reason was because the employee was black, right? So another good question is to ask them what they think the real reason is behind the adverse action, why they really think their employer fired them. Oftentimes people will have a sense of that, or a good, clear sense of it. If they signed any releases, oftentimes when people get severances, they almost always sign some sort of release. If they release their claims, they're going to be out of luck. So if they signed some sort of release, you'll want to look at that. If they were paid hourly or salary, because then FLSA and comes into play, whether or not they got paid their overtime, things like that. And then explore their performance. Oftentimes we have clients who, had a checkered past, and if the employer has a lot of things to point to for firing the employee, it's going to be real hard to show that the real reason they got fired was because they were black. So things like that. That's pretty much it. Any questions? Okay.
Thank you so much.
Thank
Lucy.
you.
So now also coming in from the green room, ITLA royalty, Shelley Fulcher-Kuntz. To talk about family law.
Yay, family law in 15 minutes. All right. Any practitioners in here that do family law? Yay! All right. So really what my presentation is going to be, it's not really about anything substantive from the law perspective. It's more of you as students, the type of data you need to collect from these people when they come into the clinic. So then when you come back and talk to the attorneys, it's more productive, the client can get information quicker, and that type of thing. So did everybody get a copy of the little family law intake? A lot of this seems like very basic information, but for those of you that have gone through divorce or gone through any sort of family law issue, it tends to be very emotional. They tend to be resistant at times to give information. And so really what we're trying to help you guys perfect is kind of the art of gathering information from people. Obviously, knowing their full legal name helps. We can look them up on the repository to see what the status of the case is if there's an action pending. The full legal name of their spouse or ex-spouse, if they'll give that to you. Same thing for repository purposes. It makes looking the case up easier. Contact information is vital if they are going to return to the clinic or if maybe one of the attorneys is going to potentially take the case on a pro bono basis or otherwise. Knowing how to contact them is helpful. And then you want to know what type of family law issue is it? Is it a divorce? Did they just get served with a complaint and they don't know what to do? Is it a situation where something's happened between them and their ex-spouse and they need to fix an order that's already out there? They need to modify custody or child support? Or is there something in an order that one of the parties is violated and so the other party wants to know what their rights are in terms of can I pursue contempt or how do I keep this from happening again? So you need to ask a lot of questions about what's going on. Tell me your story. Obviously, you don't have a ton of time, but these people tend to have a real need to want to tell their story. So to the extent that you can be compassionate and listen to what's on their mind, because typically it involves children, and again, it's hard for people to be rational sometimes when they're talking about these issues with their kids. Try and keep them on track as much as possible. But you want to know what kind of case is it. The next thing you want to know is there an action pending? Have they been served with something? Are they under a deadline? If they've been served with a complaint, they've got 20 days to get a response in. They've been served with a modification, same thing, 20 days to respond. Or are they wanting to initiate one? So you want to know, is there an action pending out there? And if so, you want to know where. Is it in Canning County? Is it in California? Is it in a foreign country? Depending on where it's filed will determine whether or not anyone in the clinic can even help them. If somebody comes in and says, well, my ex has filed an action in California and lives there with the children, they need to talk to somebody in California unless there's a family law practitioner in the clinic who's licensed in California. If it's a situation where the family's moved here recently, but they have an order in Oklahoma and they've been here maybe 6 or 7 months, but the order's still out in Oklahoma, if they haven't brought it to Idaho and had it registered and recognized in Idaho and also made enforceable, they're going to have some problems going forward until that's done. That's a multi-step process, which people in clinic can kind of walk through. Some people can do that on their own. Sometimes it's easier just to have an attorney help them fill out that paperwork. But if the action's in another state and the family has lived here, particularly the children, for more than 6 months, you're going to have an issue with who can make decisions about that custody. And under the UCCJEA, which is the federal child custody statute, that jurisdiction typically shifts when the children have lived continually in a state for 6 months or more. So big question is where, if there's an order out there, where is it? We're trying to get the family law clients to bring their most current order in with them so we can sort of see what the state of their case is. They'll say, well, under the custody order, I'm supposed to get every other weekend. Well, I like to see it in the actual order. So if they're complaining that somebody is violating the order, you can see specifically, is the order being violated? So we're trying to encourage them to bring their paperwork with them, but they don't always do it. If it's a contempt action, normally that means somebody's done something that violates the order. They even haven't returned the children on time, or they've been drunk in the presence of the children, or something to that effect. And they have the option to file a contempt action, which is sort of, there's a civil contempt and there's a criminal contempt, but essentially contempt is going to the judge and saying, hey, we have a problem here, and there's normally some penalties and fines. If they are found to be in contempt, there can even be jail time if it's severe enough. A lot of students who wander into our clinic are contempt actions, and so particularly if a contempt action's been filed against the person in the clinic, you want to know when it was filed because we've got deadlines that are running. If it's somebody that wants to file contempt, then you would want to come and talk to one of the attorneys about what is the issue. Is this a one-time incident? Is it a multiple-time incident? Has dad or mom failed to pay child support for 3 or 4 months? Those can be each separate counts of contempt, which means the penalties and potential jail time stacks on top of each other. If it's a one-time event where somebody was late returning the children one time, it may not be enough to get, it may not be enough there to justify contempt action. Normally, contempt actions are more successful when you've got a pattern of bad behavior. So sometimes we'll advise clients, let them behave badly for 2 or 3 times in a row, and then when you finally decide to file something in court, it's got a lot more teeth in it because it wasn't a hiccup, it's a habit now. So we haven't seen too many property issues come through the clinic, but sometimes, if it is a divorce, there's going to be issues regarding property. And so normally what I would encourage the students to do, first thing, ask them if they own a house together, because that's typically your biggest asset and your biggest debt. If they don't own a house, are they leasing an apartment? Are they both on the lease? That type of thing. And then you probably are not going to have time to go through an exhaustive debt list of what kind of assets and debts they have, but typically you can ask about vehicles. Are there any loans against the cars? Who's driving what vehicle? Are both parties working? If so, where, about what wage? And then that way, when you come to talk to the attorney, there'll be enough information that most of us hopefully will be able to give some sort of helpful answer or point them to a direction that they need to be. The other thing, too, I always ask family law clients is, what are you worried about? What are you afraid of? If you let people talk long enough, they'll normally start to talk about what they're bothered by. Typically, if it's involving children, somebody's made a threat that they're going to take the kids. Sometimes when a divorce is just starting, you get parties making these threats against one another, and most of the time, those threats are pretty idle, generally. There's exceptions, but oftentimes you'll have, and I don't mean to generalize, but you'll have a mom come in and she's real afraid because dad said, I'm taking the kids and you're never going to see them again. Well, absent some really extreme circumstances, that tends to not be true. So I try to counsel a lot of these people is just because the other party said it does not automatically make it so. So again, to the extent that you can kind of, you can't really be giving them legal advice, but just because the other side has made an allegation does not necessarily mean that that allegation is going to stand absent some evidence to support it. So have any of you worked in clinic before, dealing with family law? Any issues that have come up, questions that you weren't sure how to address prior to coming to the attorney? Other than the obvious legal issues. Nothing? Okay. When you do come and talk to the attorney, it's really easy for us, or at least for me, it's easier for me to track and follow what you're saying if you use mom and dad. He and she and they, by about the second time, I don't know who she or they are, and I can't speak for everybody else in the room, but mom and dad helps a lot. And then the children, son, daughter, or names if you can get names of children. It's always good to get the ages of the children. If parents are fighting over a child that's 16, that child's going to have a little bit more say in the custodial arrangement than the child that's 5. If the parties were married, you want to know how long was this marriage, especially if it's a divorce. If they've been married 1.5 years, there's probably not much debt or assets they've acquired together that's going to cause a big fight to divide those up. What else can I tell you? If it's a situation where the parties have separated, you want to know what have they done with the children. If they have children, what have they done? What's been the custody schedule up to the point that they've come to the clinic? Sometimes there'll be an order out there that says, you know, one parent gets alternating weekends, but for reasons, you know, whatever reason, they've started alternating weeks. Well, how long has that been going on? Well, it's been going on 6 months or so. Well, now that's become kind of a habitual custody arrangement. So if there's somebody out there paying child support, but they've got the child for much more time than what the original order calculated their support at, they've overpaid. So if dad is coming in saying, well, mom and I have week on, week off now, and you know, our order says alternating weekends, and I'm paying child support for alternating weekends, dad's overpaid his child support. So dad might be able to, if he moves for a modification, to have some of that support refunded back to him or credited to him going forward. So you want to get an idea of what's been the status quo for the last 6 months to a year prior to them coming to see you. Because if they've deviated from an order far enough and it's become a habit, then you know the modification typically is pretty quick. I've had a situation where a mom let a child go live with dad. You know, they were getting to teenage years and everything that goes along with having teenagers, but mom was still receiving child support as though dad was only seeing the child once a month. And after 9 months of this, dad moved to modify. And she said, oh, I'm gonna have to repay all this child support. What should I do? And I said, get ready to write a check because you've overpaid him. So potentially, and I mean, it's all very fact specific, depending on what's been going on and how far off their order they've deviated on. But you want to get a sense of what's been going on in the last year or so with the parents and the children. And then once you've been able to just basically get the information that we've got on this form, then whatever their issue is, you know, you can come back and chat with any one of us. But again, using mom and dad or husband and wife, that type of thing is helpful. We can look, you know, if they're not sure where they are in their case, we can look them up on the repository to see kind of where the court is in that sense. And then if they need help filling out the forms and things like that, I think I recognize a lot of you from the clinic. You know, there's forms that we can point to, and they can either have us help them fill those out, or they can take those. We can take those with them, bring them back to the next clinic, that type of thing. Any questions? Any questions? Yes.
I just wanted to make sure I understood that. So you said that if there's been an order, but then they deviated from the order, it sounded like you could do something retroactive with, like,
Potentially. It's like I said, it's very fact specific. In the case that I had, mom had been receiving child support for 9 months, and then they basically...
According to the order. Right?
According to the order, yes. And so, and basically what they did is they went from a primary physical custody arrangement to a joint. And after doing that for about 9 months, dad moved to modify, said, I've overpaid child support, I want to change the custody to reflect what we've been doing for the last 9 months. And the judge said, you know, I'm gonna rule in his favor unless you guys can come to an agreement. And ultimately we were able to come to an agreement where we did change the custody. We did come to a compromise on the child support, so mom didn't have to pay the entire amount back.
Oh, I would just think if there's an order there, you just got to do what the order says. But I don't do family law.
Yeah.
You have to do what the order says, and it only changes from the time of modification of order. But
Like I said, it's fact specific, and where they had made this agreement to change this custody because mom and the child weren't getting along, the court looked at that as sort of an informal stipulation to modify the custody. It wasn't a situation where, you know, a parent had refused to return the child and kept the child, say, from the summer. Then you would look at more of an enforcement. But this had kind of been an unofficial agreement that had just lingered, and then dad realized that, hey, I'm paying way more than I should. Yes?
In that type of situation, do you think the court would accept suspending future payments to let it balance out? Or does it have to be...
Possibly. Can depend on your judge. A lot of times, like in our case, when the order was entered, a new order for support was entered at a reduced rate, and then it was applied retroactively back to a certain date. So dad basically was credited for the overpayments that he had made, and then, you know, didn't start making payments for a period of time going forward. So mom went for several months without really receiving any support, and then started to receive it at the reduced rate, and by that time it evened things out. But health and welfare typically has tables and calculations of how they're going to apply retroactive support. So, or you have situations where you know, one parent's going to have to start paying more, and a lot of judges will order that whatever the new child support is, they'll order it retroactive to the month following the filing of the petition. So if you have a petition filed, say, in December, and you don't resolve the case till the following September, potentially that child support order can go all the way back to January. So, but a lot of that's negotiable. You know, most of us will try and negotiate that down so it's not such a big financial hit to parties. But I have seen judges order it all the way back kind of consistently. How have any of you family law practitioners dealt with or seen that? Have you seen that pretty consistently, that they're going back?
They generally go. I've never seen a problem with going back to the petition filing, but trying to go before that is always tough.
I would agree. You know, if you've got someone that says, oh, you know, he hasn't paid child support in 6 years, you know, I don't think you're going to necessarily get them all the way back to that 6-year mark. But, you know, in Ada County, a lot of times these family law cases take quite a while to move through the system and get resolved. So you can have easily 9 months to a year, and then that can get ordered back to that month following the filing of the petition. I mean, that's probably more than you guys will ever deal with. But so if they bring in their documents, that's always great for us to look at, because we can see what happened when. Obviously, the repository will tell us when things got filed, that type of thing. But really, your job is to sort of, when they're trying to get their story out there, which will be a lot of information that we really don't need, is what's the meat of the story that's going to be helpful for us to guide them, because you'll hear all kinds of stuff if you haven't already. A lot of it, you know, somebody's mad at somebody, and it's a lot of, you know, that dirty so-and-so. And to the extent that you can minimize that, you know, they have a limited amount of time. I always tell clients, we've got this time, we'd like to help you, so what I'm going to have you give me is the information I need to help you. And if they want to come back to the clinic at a different point to discuss more of those emotional issues, I mean, they certainly could. But yes?
So at what point, you know, we have a lot of folks come in, would you say that the clinic can help them, and then at what's the threshold, or what would you say that you would recommend that they seek and pay an attorney?
A lot of it's going to depend on your client. There are some people out there that have handled their own divorces, and they've probably done a better job for themselves than I could have done. There's some people based on education or a language barrier, where just filing a basic answer or filling out a complaint, they're not going to be able to do that. So I think you need to assess who the person is. If it's somebody that generally can probably get the initial pleading out there, but you know that once, you know, if they get into a discovery situation and all that, it's really going to be over their head, then I think at that point, you know, you talk to them about seeking an attorney and sometimes, you know, some attorneys will do just certain issues, like if they just need a customized parenting plan drawn up, and the form that the court has available is really sort of not working for their particular plan. They've got too many details that fall outside of the sort of the box, I call it, of that form. A lot of attorneys will just prepare a customized document. They may not represent them through the whole case. They can handle the case, but they need some specific forms created especially for them. And I think at that point, then, you know, they can seek someone to do that. Yes?
Not to discourage the use of attorneys, but the state Supreme Court has a lot of self-help resources for family law. And mediation is also a great way to go, too. People can't afford an attorney.
Yes, and there's great family law mediators out there. Some of them are attorneys, some of them are not, but they've all got the training that allows them to advertise out there as being a family law mediator. It is a great venue for, if you've got 10 issues, if a mediator can help resolve 5 or 6 of those, then maybe they only see an attorney for the last few things that they can't agree on, that type of thing. So it really depends on who you're talking to and what the scope of their situation is. If they've been served with, you know, a considerable amount of discovery and they're bumping up against deadlines, things like that, they may need some help. If it's somebody, you know, if it's somebody with complicated assets, they're probably not necessarily coming into the clinic. But if it's somebody coming in that, you know, has a language barrier or something to where, you know, they just really are not probably going to be able to handle things on their own, at that point I think is when the discussion would start about getting counsel involved. So, any other questions?
Thank you, Shelley.
Yes, thank you.
So let me give you guys a roadmap of what we're going to do. We have 1 more hour of this training, and Shelley's going to come back, and Mike is going to come back briefly here in a second, and they're going to talk, just give you some brief comments about, now that we've talked about the substantive part of this, what does the practical part of this look like? How do you get this information from the people who come to the clinic so that we can figure out which of these issue areas we need to talk to them about and how we talk to them about it and how we come up with solutions for them. After we do that, we'll spend about half an hour in what'll probably be relatively large groups, maybe groups of 5 or 6 of you, who will sort of, hopefully Shelley can do this, and hopefully Mike can help with this as well, and I'll do one as well, and we'll just present as a client and see if you can draw the information out of us enough that you could talk to an attorney behind the curtain and get the client on their way. So that's the roadmap. So you will have to do something in about 15 minutes. Shelley and Mike, if you wouldn't mind coming up here and talking a little bit about client interviewing and legal advice versus legal information. Just make sure you pass that mic to me.
The wireless is right in front of you. Well, so I can just wear this. Okay. Go ahead, if you want to go first.
Nope, you can go first.
Well, I thought you
Tag,
had
you're it.
you had a good point about maybe the way you interview a family law case might be different than the way you interview for a for like if it's a a personal injury case, or maybe even more so like a business case or an economics kind of related case. Anyways, when you're interviewing people, you find that people come in all different shapes and sizes, and the way they talk to you, you'll have the extremes. I mean, you'll have the people who don't give you enough information, and then you have the people who give you too much information. And you want to be respectful and you want to be empathetic, but at the same time, you can't sit there all day. And there's a lot of people who they have a story they want to tell, and sometimes it's easier to just admit that at the beginning and quit trying to steer them back to why they're there, and let them do that and get it out of their system. But when they're trying to tell it to you the 3rd or 4th time in the interview, then you might want to cut them off. But I think in general, they always say you should start general, don't be too specific, and don't be focusing in too quickly on the issues because you may miss something. But at the same time, I mean, that's a great principle, but you might be there all day. The other thing is to figure out what they want, because that's, could be, they may not want what you think they want.
And sometimes they don't know what they want. I've had lots of people call and, you listen to the story, and at the end, it's like, well, what do you want? Well, I don't know. I want justice. So they have a hard time articulating that. And a lawyer who was a good mentor to me always gave me a great analogy. He said, when you go to the bus station or the airport, what's the first thing the ticket agent will ask you? They typically ask, where do you want to go? And so that's kind of how you want to funnel these people in. I mean, you can be very straight and just say, look, I understand you're here in the clinic. We're happy to have you here. The clinic is only open for 2 hours. I want to make those 2 hours as productive as possible for you. So what I'd like to do is get some information that I can discuss with the attorney, and then you can fill in, whatever details you feel like I need to know. But your goal is to find out, where do these people want to go? Who are they mad at and why? What do they want done about it? And sometimes they don't know themselves. They just want to talk, and they want you to help them figure out where they want to go. So
when you're a newer attorney, you tend to be a little more empathetic and a little more sympathetic. And I think you need to remember there's going to be another side to this story. And you need, if you really want to get a good interview out of this person and figure out what you're going to need to do to represent them later, you need to kind of start asking pointed questions early. Now, you got to be careful because you don't want to, be too antagonistic. And you get to a point, I think we all do as lawyers, you kind of enter a phase where you get really jaded, and then you start cross-examining your people, like from the first interview, which is not great for client relationships, but so you got to be careful about that. And I think there's a balance there where you're respectful and listen and let them tell you what you want. But a lot of times they just don't want to see the other side of this. And you can just be upfront, I found, just like you just said, is just be upfront and say, you know, well, look, what's he going to say? You know, one of our standard questions, my wife's an attorney, and one of her standard questions, she does more of the family law than I do, and one of her standard questions is, what's the worst thing he's going to say about you? You know, and then because she always says, what's the best thing you can say about him? Because she always tries to bring it back to, we want to be in front of the judge and look good. You know, we want to be the party who's doing the best for the kids and trying to salvage the relationship. But anyways, be careful of that. And just be careful of there's two sides to every story. And then also, if they are ramblers, I mean, there are these people who just ramble, and they don't know they're doing it. I mean, it's almost like a mental problem or something, and they just don't know. But you can sort of tell them, I think it's appropriate to just say, you know, you've kind of, okay, you keep saying this, but we've got to get back here. And you got to do it in a tactful way. I mean, but you do, I think it's appropriate to do that. And at some point, though, you just have to cut off the interview. That was the other thing I was going to say. Sometimes there's an awkwardness to when you're done. And maybe because I work for Idaho Legal Aid, and so, you know, they're not paying me for their time, but I find, like, you have to have, like, a closing kind of question. Like, okay, so this is it. And they always kind of want to know, where do we go from here? If nothing else, it's just, you know, well, we'll talk later, or in your case, you have to go back. You have kind of good out. Because you always have to say, well, I got to go back to, I guess, if I understand this right, is you always go back to the attorney and say, you know, you're not making a commitment what I'm going to do next and that kind of thing. Is that right? How this
is, yes.
What we're talking about.
Yes, and I think the other thing that's really important, I mentioned this in a prior training, there was a lawyer, Louis Nizer. If you guys don't know who Louis Nizer is, it's N-I-Z-E-R. He has a great rule of probability about what is expected, and one of his little key themes was listen for what's missing. Listen with that third eye. You know, if somebody's going on and on and on about a particular fact pattern, and, you know, listen for what they're not telling you, because it's amazing what they won't tell you, because they want themselves to look good. And that's why I like the repository. I will talk to people on the phone, and as I'm talking to them on the phone, I'm pulling them up on the repository, and I'm seeing page after page after page of stuff while this person's painting themselves as, you know, the most, you know, law-abiding citizen there is. So listen for what's not there, and don't make them promises. You know, and the nice thing about the clinic for you guys is there is a very limited amount of time, and so you can blame the time limit of the clinic for why, if they start to rant, that this is not the most productive use, because if they spend the whole time, you know, telling the story, then they've got to wait almost a month to come back. I mean, potentially 2 weeks depending on the issue, but for them, I mean, their time is valuable. I mean, your time, you will learn, is very valuable, but so is theirs. So to maximize the benefit you can give to them is to really say, hey, you know, this is kind of what the information I want to get. I want to get an answer for you. I want to, you know, hear what you have to say, but I want to make sure your time here is used as efficiently for you as possible. And most of the time, they will really appreciate that. Because there are places to have the big story. If it's a family law case, mediation's a great place to do that. Because most of the time, they just want to feel like they need to be heard. And there's a real drive for pretty much everybody in most cases, I would say, to just be heard. But clinic may not be the place to do it. So, and again, you can, you know, depending on the attorneys, we kind of come and go out of the clinic depending on our schedules. You can always say, hey, there's a great attorney I really want to run this by, but I know they're only here for a few more minutes. So let me get this, I'll go ask them, and then we can come back and talk some more. So don't be afraid to use either the time limits of the clinic or the attorney scheduling to cut that off.
And if you have access to, like, the website, I mean, to, like, the repository while you're sitting there, which that's a good resource, because a lot of times these folks don't know procedurally where they are in the system. And so looking stuff up can be very helpful, because they don't, you know, they'll be telling you about, well, I don't know what's going on, and you'll be like, well, you have a trial tomorrow. You know, I mean,
That's happened.
I've been there.
Surprise.
So, you know, and they don't know, you know. So anyways, that's, and then sometimes to end an interview, like I often find, finally, there's some really hard people, you just got to stand up. You know, you just got to stand up, okay, you know, and kind of trying to shove them out the door, you know, and they're still like talking, you know, and talk you down the hallway. But I don't know, maybe that's just me, but anyways.
Questions, thoughts, fears? For those of you that have been in clinic before, do you know how to look things up on the repository? Okay, because we'll always have a laptop there, and you know, if you don't have time to do it, one of the attorneys will do it. That's not a problem. But if you don't know how to do it, you just basically Google. You can Google Idaho Judicial Repository, or the website is. Yes, thank you. I'm glad she knows it because I don't know how to Google it. I have a book.
Code number they make you type in with like a
capture.
there's like 10.
But it used to be a word when I could never read the words.
Yeah,
so.
now there's like 10 numbers.
Yeah, the numbers
which
are
really
much better.
little. God, it drives me crazy. And I don't
Right.
Anyway.
How
Yep.
many people show up for this thing?
Depends on the
most
clinic.
we've had is 25, and the least we've had is under 10. We've been able to see every single person that's come into the clinic, and we've been open for a year in February. So that's pretty positive.
And when you say 25, you're talking about people staffing the clinic, not people
Clients.
or clients. Okay.
Yeah. So it depends, you know, depending on how many law students we have and how many people we can get through, because the intakes are the longest part. So that's the students. So depending on how many students we have, it can go quick.
Right.
How many students do you have?
I try to have at least 6. Sometimes it doesn't work out that way.
Is it divided up? I mean, do you have like lines, like if you've got family issues and this, so people can go for particular lines, or?
Is it okay then?
Oh yeah.
Okay. So we
No,
have.
not allowed you.
I'm sorry.
No, go ahead.
I don't want to be talking out of turn. We have 2 clinics. So if you're not familiar, we have the Street Law Clinic. Here, I'll get up and stand. We have the Street Law Clinic, which runs on the 2nd Monday of the month, and then the Family Law Clinic runs on the 4th Monday of the month. So people who are coming to the 4th Monday, it's all family issues. So that's pretty simple. And I staff it with only family law practitioners for volunteers in the back. But for the Street Law Clinic, we don't divide it. It's first come, first serve. So when someone comes in, when I open the doors at 4 o'clock, I don't let anybody check in before 4 o'clock. I number them, and law students take them as they can, and then they, you know, they're completed as they kind of go. So sometimes it feels really chaotic, but we've always been able to see everyone, and we're always out of there by 6:30, no late, and yeah.
And you'll get family law people coming to that general street law clinic, which is fine. I mean, you know, we try to have somebody that does, yeah. So, I mean, we would never turn someone away that came, or if somebody showed up at the family law clinic with a landlord-tenant issue, we're not going to turn them away. I'll be calling someone because I don't know anything about that, but.
So, from what I've gathered, the law students interview and attorneys are somewhere else and never actually have
Yes.
interaction with the folks?
Actually, that's not true, and they can kind of do it. We want them to have interaction with the attorneys as well. But the initial meeting is always with just the law student. Typically, the law student goes back. We call it behind the curtain. I have a curtain there now, but it'll probably go away soon. But yes, they are separated, and that's just because the attorneys are in the back working on multiple things, so that when the law student comes back, they can kind of just talk to whoever's available. But oftentimes, the attorney will come back with the student and kind of go over some things or answer in-depth questions or whatever it needs to be.
So what we're going to do now is, and hopefully I can rope in Shelley and Mike for about half an hour to do this, is if the law students who are here, who are going to be doing the clinic, if you guys could, and I don't care how you do it, organize yourself into 3 groups of roughly the same size. I can give you people you like, and people you don't like, it doesn't matter to me. Just 3 groups.